Welcome to Live at Lunch. My name is Emily Sumner from Sumner Immigration Law, and today we are talking about what to do if you or your employee was selected in the H-1B lottery. First of all, if you or your employee was not selected, or if you have multiple employees not selected in the H-1B lottery, take heart. I'm so sorry that didn't happen for you, but there are potentially other options. And we are delving into that in a lot more detail tomorrow in a free webinar that we're hosting tomorrow at noon Eastern. I will put the link in the comments to sign up to register for that webinar if you're interested. Even if you can't attend live, we will send the recording to everyone who signs up. So please join us if you're able to for that, either live or on the replay. In the meantime, I want to welcome everybody who's watching live or catching the replay to learn about what the next steps are if you were selected in the H-1B lottery. First of all, congratulations. And what is the H-1B lottery? The H-1B lottery is a lottery, as the name implies, that USCIS conducts at the end of for every employer who registered in the H-1B Cap lottery. So the selection was complete as of last week, supposedly, although we did have selections rolling in over the weekend, but it is completed now. USCIS has sent an email confirming that they have completed all the selections. So we know by now. In our office, we've notified all of the employers who have selections, and we've notified all the employers who do not have selections in the process. So you should know at this time if you are selected or not. If you are selected in the lottery, or if you have employees who have been selected in the lottery, the first step that I would recommend, and this is not legal advice, this is just general education, general information, but the first thing that I would recommend is to have a conversation and make sure that your employee is ready to proceed with the filing. I say that because the H-1B lottery process, the selection process rather, changed this year to become beneficiary centric. By the way, as a side note, we do not have information that I've seen yet as to how many registrants there were, or rather how many registrations or how many beneficiaries were selected in, or rather were entered into the lottery. I haven't seen that number yet. I'll share that as soon as we have it. But statistically speaking, and of course, our group of registrations is not statistically significant, but we did have about 26% of our registrations selected in the lottery. And I'm seeing that somewhat consistently with other immigration attorneys as well. Some are saying 25 to 30%. Of course, it depends on a number of factors, but it's significantly higher than last year when our selection rate was about 10%. Nationwide, it was about 14%. Of course, there are going to be some attorneys or employers who registered multiple, entered multiple registrations and nobody was selected. Unfortunately, that happens, but the percentage overall that we're hearing about, at least anecdotally, and that we're seeing is a lot higher. That is likely because USCIS changed the selection process. And this goes to my first point, my first step about what to do. So this year, USCIS changed the selection process to make it beneficiary centric. That means that they made selections based on the foreign national's unique passport number. So they didn't make the selections based on the employers, but rather based on the beneficiary's unique passport number. So let's say that there is a foreign national named Jane Doe, and she convinced, one way or the other, multiple employers to register her in the H-1B lottery. Let's say she convinced companies A, B, and C to register her in the H-1B lottery, and Jane was selected in the H-1B lottery. That means now that Jane potentially could have all three companies, A, B, and C, file H-1B petitions for her, and they could all be approved, but she would only be counted once in the lottery. So again, she could have three employers petition for her if they had registered her in the H-1B lottery. And if she was selected, she could have all of those employers file for her, and she could potentially work for multiple employers. She could choose to work with one of them. It just depends on her particular situation. But I say that because if you're the employer, make sure you have a conversation. I would want to know, if I were the employer, if my employee had registered through multiple companies and had other companies sponsoring them as well or filing a petition for them as well. with USCIS. So I would say I'm all about transparency. Transparency is one of the core values of some immigration law. So I would have that conversation with the employee or with your employer if you are the employee, and be straightforward about it, because it doesn't make sense for an employer to invest the time and money in filing if the employee is going to go work for someone else. So hopefully that's not the case for you. Hopefully the employer is the only employer and you file and the petition is approved. So first step is to have a conversation. Second step is file the petition. So the question is when to file. The filing window is open from April 1st to June 30th, and you have to file within that window. It's not okay to file after June 30th, at least for this round of the lottery selections. The start date that you request, and this is something that your immigration attorney can advise you on further, but the start date that you request, unlike previous years, does not have to be October 1st. It can be later than October 1st. It has to be within 180 days of filing the petition. The start date has to be within 180 days, but it can be a later start date, which is a nice change from previous years. So you do have to file within the 90-day window. What and where to file? Note that the form versions have changed as of April 1st, and there's no grace period. So you have to use the new form editions starting now. In addition, there are additional filing fees, as we've talked about in several previous lives that we've had, and there are new filing locations. So as you file, make sure that you that your attorney is going through that quality assurance process multiple times, as our office does, to make sure everything's filed correctly, the right documents are filed. We advise clients once they have retained us for the immigration process or for the H-1B process exactly what documents to include. Generally, it's documents like information about the beneficiary, their passport. We may want to review their resume. We may or may not include that. Their degree information, degrees and transcripts, information about the company, information about the position offered, that type of thing. So make sure that you start gathering that information now, so you can definitely file within that 90-day window provided. The question of one of the next steps I would take is have a conversation with your immigration attorney, with the employee, employer, and immigration attorney about whether you're filing for consular processing or for change of status. If you are located here in the United States and you want to change your status, if you're in valid status, you want to change your status from F1, for example, or H4 or L2 to the H-1B status, then in general, there are exceptions, but in general, you can request a change of status, and your status would change automatically to H-1B as of October 1st of this year, or the start date that you request, whichever is later, or when the petition is approved. There are lots of moving parts here, but just know that it is possible in a lot of situations, not all situations, to file for a change of status. That means that to make your H-1B status effective, you don't have to leave the country, get the H-1B visa stamped, and then come back in. So that's the benefit, is that you don't have to leave. You don't have to worry about consular processing. One thing to be aware of if you request the change of status is that your status, if it's approved, if the change of status is approved, your status will change automatically from whatever you're on right now to H-1B as of the start date that's requested, as long as it's after October 1st, on or after October 1st, and as long as your petition is approved before then. So know that it changes. I've over the years had situations where clients come to me after the fact and they didn't realize, it's not a petition I filed, but somebody else filed it, and they didn't realize that their status had changed and they had thought that they were maintaining a different status. That can be a problem. So know that if you file for a change of status, your status will change automatically. You should receive, or your employer should receive, the approval notice with the I-94 at the bottom that indicates that your status is now H-1B and the effective dates to and from. Consular processing means that you request that the petition be sent overseas and that you will go to the U.S. consulate to get the H-1B visa stamped. There can be strategic reasons to request this. For example, if you want to max out the amount of OPT time that you're working, maybe you have another year, for example, of STEM OPT, and you want to max that out before you begin your H-1B status. I talked about that a little bit in last week's live, if you want to check that out. That is a possibility, to request consular processing, and then your status, your H-1B status, does not become effective until you leave the United States, get the H-1B visa stamped, unless you're Canadian, and then re-enter the United States. So that's a consideration, a good conversation to have to make sure that everybody's on the same page about when your H-1B status will become effective and how. I think we're on number 4. The next thing to have a conversation about or to think about is the H-1B Cap Gap. The H-1B Cap Gap is an amazing part of the regulations that allows for foreign national students who are working in the United States on OPT, optional practical training, to be able to cover the gap of time, if there is one, between the end of their OPT and the beginning of their H-1B. So, for example, let's say that you have an employee who is working on OPT and their OPT expires on May 15th, 2024, for example. This part of the regulation says as long as you meet certain requirements, that when you file the H-1B petition, again, you have to meet certain requirements, but when you file the H-1B petition, even though it's not approved yet, their work authorization will automatically be extended. Their OPT will automatically be extended until until September 30th. So that is a way that the beneficiary, the foreign national student, can continue working. There are certain requirements that you have to meet. So make sure that you have a clear conversation with your immigration attorney about that. For example, you have to request a change of status. You can't request consular processing. The petition has to be filed before the current OPT expires. So make sure you have a conversation about that, but have that conversation and know if you're going to take advantage of the cap gap. That can be a really great benefit. As of right now, that cap gap would expire on September 30th, whether your H-1B petition is approved or not. So once you get to, let's say, the end of August, maybe in the middle of August, if your H-1B petition is not yet approved, you may want to think about upgrading it to premium processing so you can continue working beyond September 30th without interruption, assuming the H is approved. The next thing to think about is travel. So travel outside of the United States can be permitted between the time that you are selected in the H-1B and the time in the H-1B lottery and the time, that's my dog Kelly behind us, the time that you're selected. Hi, Kelly. The time you're selected and the time that you have the H-1B petition approved and in effect. Have that conversation. Tell your employer and your immigration attorney if you plan to travel, please. That will help us out. That will help us advise you and make sure that everything goes as smoothly as possible. Know that it is possible in some situations to travel internationally and to come back in. But we have to be careful about the timing. Namely, and there are other considerations, so this is not legal advice, talk to your immigration attorney. If we are your lawyer, which I hope we are, I'm happy to have a conversation about this so that we make sure everybody's on the same page. But if you travel while the H-1B petition is pending, and if you requested a change of status, the change of status portion of that filing will be denied, and you'll have to do consular processing. So again, have a conversation. If you have travel plans, let's come up with a plan to make sure that you have the optimal experience, the best experience possible. The next step is to start now. This is near the end of our steps here. Start the process now. I know you might be thinking, oh my goodness, we just got through this registration process, the whole fee change thing. It's the beginning of a Q2. Let's just take a minute. And that's totally fine if you want to take a minute, but know that you have 90 days to file this until June 30th to file. And it is very stressful, honestly, even to file in June, because if something goes wrong with that filing, if heaven forbid, the check isn't signed correctly, or it's the wrong check amount, or a box is marked incorrectly, that petition can get sent back. And if it does, you're out of luck until next year, and you have to register for the lottery again and hope you're selected. So I love getting all the filings in April, or at least by May, so that we have some breathing room. Hopefully everything goes smoothly, it's accepted, everything's fine. But it can be really stressful just in general to pull things together at the last minute. So start preparing everything now and come up with a filing plan now. My last recommendation, and again, not legal advice, but my last thing that you should perhaps think about is next steps. And it's okay to think about this after you have the H-1B petition approved, but I want to put this seed of thought in your brain, whether you are an employer or an individual in H-1B or who will be in H-1B status. That is that the H-1B status can last up to 6 years total. it is possible to extend the H-1B status beyond the 6th year if you are at a certain point in the green card process. And that's complicated. We can talk about it in another video, but it is possible to extend, but only if you are at a certain point in the green card process. So start thinking about now, if you're an employer, what your budget is, if and when you are willing to invest in the green card process for this employee. Think about your immigration policy, if you have one, and how that would apply to this particular person, if you're willing or able to make an exception and start sooner rather than later. But know that waiting until year 4 or 5 of the H-1B status is not the time to start thinking about the green card. Really, it's sooner rather than later. And I'm not saying that you need to start it immediately, but it is something to just have in the back of your mind. It may not be something that you ever end up doing for this particular employee, or if you're an employee, you may not do it with this employer, but a subsequent one. But just know that that's something that you should be thinking about, both as an employer and employee, if you want this person to stick around long term, or to be able to keep working in H-1B status or another classification long term. So that's the information that I have for today. Again, my name is Emily Sumner from Sumner Immigration Law. We serve clients throughout the United States and around the world, helping them navigate the employment-based and family-based immigration cases with confidence and less stress. I hope that you'll subscribe to this platform so you don't miss our next video. If you have questions, feel free to send us an email at info@sumnerimmigration.com. Until next time, I will be back live next Tuesday at noon. Take care.